My name is Mark Clough QC. I am the head of the competition law team in the Public Law and Regulatory Division of Brodies. We advise a variety of clients, including the food and drink sector. Increasingly, legislation emanates from the EU. Brodies is the only Scottish law firm to have an office in Brussels. This enables us to assist clients in keeping up to date with the regulatory developments. Competition law covers a variety of business practices, starting with merger controls, distribution agreements, price fixing or market sharing cartels, state aid and public procurement. Competition law is of crucial importance to the food and drink sector. It has a number of major risks that need to be managed because it is a very high-profile area of regulatory enforcement these days. Competition compliance is very much on the agenda in the food and drink sector at present because of the recent appointment of the Grocery Adjudicator, a lady called Tacon. Her role is to enforce the Grocery Supply Code of Practice. The purpose of the code is to regulate the relationship between the suppliers and the major retailers. I can offer 5 top tips to the retailers as to how to deal with the Grocery Supply Code of Practice. The first requirement that they must satisfy is to have an agreement with each supplier in which they include the obligations under the Code of Practice that they must satisfy. The second is that they must give a copy of that agreement to each supplier. The third is that they must prepare on an annual basis a report that they submit to the Grocery Adjudicator to demonstrate how they have complied with the code. Fourth, they must implement a compliance program to comply with the obligations imposed on them under the code. And fifth, in that connection, they are obliged to train their staff to make sure that they are familiar with the code and will comply with it. For suppliers, my 5 top tips would be as follows. First, they need to make sure that all their staff who deal with the retailers are fully aware of the obligations imposed on the retailers and of the procedures and remedies available to suppliers under the code. Second, they are able to complain on a no-names basis to the Grocery Adjudicator. Third, the supplier may ask the Grocery Adjudicator to investigate the conduct of a particular retailer. Fourth, the Grocery Adjudicator has the power to impose financial sanctions at the end of an investigation. Fifth, it's useful to know that the retailers are to bear the costs of any complaint or investigation brought before the Grocery Adjudicator. Brodies is well placed to advise food and drink businesses because we have a specialist food and drink group in the firm that operates across all areas of legal practice. In particular, we have considerable experience in the competition law field of advising and representing the food and drink sector, whether it's in the context of merger control or OFT investigations, or indeed in litigation before the courts, both in the UK and at the EU level.